once again to Law Cora, and here in Law Cora we share legal ideas, legal opinion. This is an interactive platform where we discuss law related issues and also deal with law courses and answer some law questions. So here is a platform for all of us to interact, communicate, and share our own views, and also discuss how we can improve our legal system, both as regards Nigeria and also globally. So, my name is David Njoku, and I'm the founder and CEO of Law Cora. So, I'm a law student, and we are all here to share ideas and interact. We are all here to learn from each other. So, the essence of this platform, like I've stated in the previous episode, is for educational purposes so that we can interact and discuss law issues, because law is a very interesting and fundamental aspect of our society. And so having a platform like this will enable us to pour out our legal opinions, which you never can tell can be useful in the future. So today we'll be discussing, our topic for today would be on the sources of law. My apologies, in the previous episode we were supposed to complete the classification of law, but due to the fact that common law and equity, which is also a classification of law, is very bulky and voluminous, it would not be wise if we talk about common law and equity in this particular episode. So in the next episode, we will discuss common law and equity extensively. We'll break it down and expatiate on common law and equity and the history of common law and equity. So today our major focus will just be on sources of Nigerian law. So when we talk about source, what comes to your mind? When you talk about source, what will come to your mind is where something is originating from, where is something emanating from, or where is it developing from. So sources of law have a variety of meanings. So under this variety of meanings, we have the material sources, we have the formal source, and we have the literary source. Now, the material source is further subdivided into two. The material source has the legal material source and the historical material sources. So now, material source means where the law is made. And so under this legal material source, which is under the material source, legal material source refers to the direct means through which the law is made. I repeat, legal material source is the direct means through which the law is made, and it includes statutes, precedents, legislation, etc. Those are the direct means through which the law is made. On the other hand, historical material source refers to the means through which the law developed. From the word historical, you know that it's dealing with history. So this is the means through which the law developed, and they include the customary law, the custom, statutes, and even some Roman law and custom also constitute this historical material source. So that is for the material sources. Now, the formal source. The formal source of law is where the law derives its authoritative and binding power from. So when we're talking about the formal source of law, we are talking about where this law is deriving its power from, where is deriving its strength from, where is deriving its strength from. So that's the authoritative that is the formal source of law. And the examples and instances, for instance, in a democratic society, it is the will of the people in a democratic society. Then it is also the will of the dictator or the monarch in an absolutist society, and it is the will of God in a society that is practicing theocracy. So when we're talking about the literary source, this is what they're talking about. Sorry, when we're talking about the formal source of law, this is what should come to our mind. Then the next one is the formal source of the literary source, literary source. The literary source, this is the codification of laws, the code itself, and is kind of similar to the legal material source. The literary source is similar to the legal material source. So examples of these literary sources two major sources of law in England. This include the statute, and case law. So we can say these are examples of literary sources. So that's settled. We have talked about the variety of meanings as regards the sources of law. So now let's explain extensively on these sources. Let's explain these sources of law. So in no particular order, I'll be identifying the sources of law, and I'll be categorizing them into 5. So the sources of law, the number one I'll be giving is the Constitution. The Constitution is a source of law. Then the second source I'll be giving is the Nigerian legislation. Then the third I'll be giving is the Nigerian case law or judicial precedents. Then the fourth I'll be giving will be the received English law. Then finally, the last will be the customary law, stroke Islamic or Sharia law. So these are the first and foremost, the sources of law classified under primary and secondary. So the primary sources of law, these are the ones that I've mentioned already. Then the secondary sources of law, these are the law textbooks, law journals, periodicals, interviews. Those ones are the secondary sources of law. And the primary sources of law are binding. They are binding and very authoritative, whereas the secondary sources are merely persuasive. They have no strong compliance in courts. However, the courts may rely on it if there is no evidence of that law on the primary source of law. If that particular law cannot be found in the primary source of law, then they can refer to the secondary source of law. So we're going to be starting by explaining the Constitution. Now, the Constitution as a source of law, obviously, The Constitution is the crown norm. It is the fons et origo. Some regard the Constitution as the Alpha and the Omega. So, the Constitution is a creature made by the Creator the Constitution is a creature made by the Creator to govern the affairs of the Creator. So, Constitution is made by us to govern our affairs. So, the Constitution we have in Nigeria is the Constitution of the Federal Republic of Nigeria 1999 as amended, and the Constitution has undergone several amendments. The Constitution of Nigeria has undergone several amendments. So that is for the Constitution. Then the next source of law I'll be discussing is the Nigerian legislation. Now, the Nigerian legislation refers to acts of parliament that is made by the National Assembly. So, first and foremost, this legislation is divided into 5 main forms, which includes the ordinance, acts, laws, decrees, and edicts. So the ordinance refers to laws that were made by the federal legislature before October 1st, 1954. These are the ordinance. Whereas the next one is the next one is the acts. Now, acts are the laws that are made by the House of Assembly. So it could either be the national acts are laws made by the National Assembly. Acts are laws made by the National Assembly. Then laws are now these are the ones that are made by the State House of Assembly. And the National Assembly consists of the House of Rep and the Senate. Then the State House of Assembly, what they make is regarded as laws. That is what is known. That is the name is called laws. Is regarded to be laws. So what the State of Assembly makes is laws. Then for decrees, this is made by the federal military government. Then edicts is made by the state military government. So when we're talking about legislation, we can't talk about the Nigerian legislation without mentioning these 5 forms, because they are very crucial aspects, the fundamental aspects of your legislation. And also, a legislation can also be delegated. That is why we have what we call delegated or subsidiary legislation. Now, delegated or subsidiary legislation refers to powers being vested on a body by an enabling statute of the National Assembly. I repeat, delegated legislation are powers vested on a body by an enabling statute of the National Assembly. So the body being delegated the power must act in consonance with the enabling statute. They must not act ultra vires. When we say somebody is acting ultra vires, it means that particular body is acting beyond its power, beyond its constitutional power. So the delegated legislation, they are inferior to the enabling statute. That is to say, the enabling statute can appeal or amend their powers. So they only work in consonance with the laws that is the statute that is enabling them. So that is for delegated legislation. Now the next one we'll be talking about is the Nigerian case law or judicial precedents. Now, case law. Case law is a doctrine that is founded on the principle of stare decisis. That is standing on the decision. So, case law or judicial precedents means following the decisions of, it simply means the past decisions of courts, following the decisions of the higher courts, because the lower courts are bound by the higher courts. The lower courts will follow the decision made by the higher courts. They won't act in their own authority. For instance, in Nigeria now, the decision of the Supreme Court is binding on the Court of Appeal. The decision of the Court of Appeal is binding on the high courts, whether federal or state. The decision of the high courts is then binding on the magistrate courts and the area courts. So the decision of higher courts, they are binding on lower courts, whether of coordinate or subordinate jurisdiction. So that is the main purpose of judicial precedent. And judicial precedent is very necessary for an organized legal system, because without this proper hierarchy of courts, without this established higher courts and lower courts, different courts will be given different decisions. The high court may give a decision that is different from that of the Supreme Court, and the high court may not be bound to follow the decision of the Supreme Court. So to ensure predictability and to ensure fairness and to make our legal system organized, the lower courts must follow the decision of the higher court, unless the decision of the higher court was so unjust that it cannot be able to reflect both the spirit and the letter of the law. So that happens in rare cases, and the judge in that particular case will have to give a huge reason for that. So now, speaking of reason, it brings us to ratio decidendi and obiter dictum. Now, ratio decidendi simply means the reason for the decision. Ratio decidendi is the reason why a judge made his judgment. This is the statement that is based on the principle of law. So the judge bases his judgment on the principle of law, based on the facts and evidence that is brought before him in court. So that is what we regard as the ratio decidendi. And ratio decidendi is what is binding. This is what the lower courts follow. The lower courts don't follow the obiter dictum. Now, the obiter dictum is regarded as statements made by the way. Statements made by the way they are statements made by judges. If, for instance, now the case was of different facts, the judge would give a statement he would have, a judgment he would have made if the case was of different facts. So the obiter dictum is where the judge drops his opinion, his legal opinion. So the obiter dictum is not binding, it's merely persuasive. However, it may be relied upon in a later case, but the courts are not bound to follow the obiter dictum. They are not bound to follow the obiter dictum, so one can only bring it in court as a persuasive use, or the judges can only make it for persuasive purposes, but it's not going to be the ratio decidendi. So that is for the case law or judicial precedent. So now the next one I'll be talking about will be the received English law. So when we talk about received English law, we're talking about the laws that we received from Great Britain, because we were colonized by Britain. So some of their laws were incorporated and indoctrinated in our legal system. So these laws are what we refer to as received English law, and they include the common law, equity, and the statutes of general application. So these laws, they were inherited from our colonial masters, you understand, which is Britain, and they can be found in our present legal system. So when we talk about received English law, one may ask, why are we practicing this received English law? Why is it enforced in Nigeria? It's not our own local law. It's not our own local law. So why are we going to be applying the laws of England when we are no longer responsible to them? We are now an independent. Nigeria gained its independence October 1st, 1960. So one may ask, why are we still practicing the received English law? So it is pertinent to note that the authorities backing the application of received English law in Nigeria. So Section 32 of the Interpretation Act provided that the common law, the doctrine of equity, and statute of general application that were in force on January 1st, 1900 shall apply to Nigeria. Also, the Supreme Court Ordinance of 1914 provides that the common law, the doctrine of equity, and the statute of general application in force on January 1st, 1900 shall have jurisdiction in the courts. So we can now see that the authorities backing the application of the received English law in Nigeria. So this is the reason why it is being practiced here. However, the ambiguous term here may be statute of general application. That may be the ambiguous term here. And one may ask, what is this statute of general application? What does it refer to? What is it all about? So statute of general application, we can follow the definition that was given by the Interpretation Act and Supreme Court Ordinance of 1914. So they referred to statutes of general application as to all the laws that were in force in January 1900. So we can see it is very clear. It is very, very clear. They have simply stated that the statute of general application are laws that were in force on January 1st, 1900. That is to say, if that law was not established in January 1st, 1900, it is not going to be received as a statute of general application. It must have been in force in January 1900 in England before they can regard it as, this is a statute of general application. So that is what that particular act is saying. So unfortunately, one might say that definition is inadequate, is not contextual. So different courts have tried to expatiate the definition of the status of general application. So in the case of Chief Young Dade versus African Association Limited, the courts define status of general application as not only laws that applied strictly to England, but laws that apply to the entire United Kingdom. So, a common misconception which I was once guilty of was that, when people want to refer to as UK, what comes to their mind is England. When someone say, I want to go to UK, I want to go to England, I'm coming back from United Kingdom, everybody has this belief that UK is England, England is Britain, and Britain is UK. But most people are not aware that United Kingdom is made up of 4 countries. So in the United Kingdom, 4 countries make up the United Kingdom. This include England, which is the most populous and the biggest country in the United Kingdom. The second one is Wales. The third is Scotland. Then the last one is Northern Ireland. So when you're talking about what this particular case is saying is that statute of general application is not referring only to laws that were enforced in England, made in England. It's also saying laws that were enforced in Northern Ireland, laws that were enforced in Wales, laws that were enforced in Scotland, all the countries in the United Kingdom, all of them, is regarding to all of them as status of general application. You get? So also, in the case of Lawal versus Yunnan, the court held that the Fatal Accident Act of 1846 and the Fatal Accident Act of 1864 are all status of general application as they concern the citizens. So these are cases where the law was trying to explain in detail what the statute of general application is. What the statute of general application is all about. So you can also read up Young versus Abina. Is also talking about the statute of general application. So moving further, the next primary source of law we're discussing is the customary law. So when we talk about customary law, what comes to your mind? When you talk about customary, you're talking about custom. What is the custom of the people? What is the habitual course of conduct of a particular people? So this is what we refer to as custom. The habitual course of conduct, what the people have been doing in practice. What people have been doing in practice from time ab initio. Those are customary law. So just note that even though now today that some customs are now documented, but customary law is largely unwritten. Customary law is largely unwritten. This is because in the past, when the people that lived in the past, what they did was to pass their laws from generation to generation. Majority of them were not really that interested, or they didn't have they were not that educated to know that these customs need to be documented for proper referencing, and so that it can be relied upon in any situation if somebody is found erring or breaching of any of the customs. But not regardless, they still constitute primary source of law, because we cannot jettison our customs. The only thing the court can do is to remove customs that are not good, that are repugnant or against natural justice, equity, and good conscience. So that would be under the validity test for customary law. So we'll just briefly summarize this customary law. because customary law too is also bulky, and it will be a separate topic in a particular episode. So customary law, as we say, is just simply the custom of the people, the habitual course of conduct of a community. So in the case of Lasanjang versus Dangobe, the court defined customary law as the unrecorded tradition and history of the people. You see, so it's still saying it's unrecorded. That is it's not codified. So it's the unrecorded tradition and history of the people. So forging ahead, this customary law, it has different features. We need to know the features of the customary law. So one of the striking features of the customary law is acceptability and flexibility. Customary law must be accepted by the people in a community. It must be accepted. So, I was supposed to talk about it in the last episode when I was giving my own definition of law. I didn't talk about the fact that the law must be binding on the people. When we say law must be binding on the people, it means the law must be accepted by the people. The people must accept, we want this law to be binding on us. You cannot make law that is against the people. You have to make law for the common good of the people. So, for it to be binding on the people, it means the people mutually assented to that, agreed, and say, we'll follow this particular statute, we'll follow this law, because it's not against our moral beliefs, standard, and all that. So the same way customary law, it must be accepted by the people in that community, and it must be flexible. It must be willing to, the society evolves, so it must be willing to adapt to the current situations of a particular society. So that it must be flexible. So in the case of Owoniyi versus Omotosho, the courts defined customary law as a mirror of accepted usage. So another feature of customary law is that customary law is largely unwritten. I've already said this earlier. Majority of the customs are not codified. They were not put in any document. They were only passed on by word of mouth from generation to generation. So you can see the case of Alpha versus Arepo. You can read up the case and know what the case is talking about. So another feature of customary law is that customary law must be in existence at the relevant time in question and accepted by the people. So you can't say something is a custom if it's not in existence. This was evident in the case of Lewis versus Bankole. You can't say something is a custom and the people are not aware of it. The people are not practicing it. So for you to bring a custom to the court and say, let the court refer to this as a customary law, the court will have to make some investigations. This particular custom, this person is saying, is it applying in this particular community? And if at all that custom is in existence, did the people accept that custom? Do they practice it? So these are the things to note when talking about customary law. So this customary law also has validity test. I'll just talk about the validity test. Like I said, in our next episode, in a future episode, we'll discuss extensively on the customary law. But because of time, we won't go into detail. So the validity tests include the repugnancy test, incompatibility test, and the public policy test. So we can just, in a future episode, we'll explain extensively on this the test of validity for customary law. These three tests are what a custom must pass through before they can say, this custom should be applied. This is what the court will look at So a custom must not be repugnant to natural justice, equity, and good conscience. So the courts will look at, does it pass the repugnancy test? Does it pass the incompatibility test? Does it pass the public policy test? Is it against public policy, public morality? These are the things the court will look at before saying we can adopt this as a customary law, because there are some customs of the people that the court jettisoned. The court said no, it cannot be in practice. The court says barbaric. The court says it's inhumane, it's degrading, doesn't have respect for human dignity. So that is for the customary law. So the next this thing we'll be looking at, the next source of law. Okay, before this customary law, I joined it together with Islamic Sharia law. So most people are of the view that customary law and Sharia law, that they are the same. That Islamic law and Sharia law are the same and they should not be separate. But me personally, I'm of the view that they are separate laws. The argument is that it's the same because Islamic law is only practiced by those who practice Islam, especially in the north. It's not applicable to everyone. But I still believe that it's a different source of law. It's not the same as customary law. My number one reason is because Islamic law is written, unlike customary law that is largely unwritten. So we cannot say a law which is mostly documented, that is in its entirety. Islamic laws, all of them are codified. So we can't attribute that to be also customary law, because customary law is largely unwritten, while Islamic law is written. So I see it as a different source of law. But however, for the purpose of education and for educational purposes, Islamic law refers to laws that made by the Holy Quran. So these are religious laws that the people of Islam they follow, and it's being documented in the Holy Quran. The people who practice the Islam, the people who practice that is why you see in the north most of some of not most rather some of their cases are being judged in Sharia courts, because the northerners have their own moral standard, which they also have penalties attached to it. So a breach of which they will be punished under the Sharia law instead of a regular court. Under the Sharia court instead of a regular court. So that is why I say that Sharia courts are that Islamic law is distinct from customary law. So with that, we have discussed the primary sources of law. We have identified what these primary sources are, and the next one is the secondary sources of law. This is not secondary sources of law. Is not these are just persuasive. They have no binding force. You get secondary sources of law. They are not binding, so they include law textbooks, periodicals, journals, interviews, symposiums, international treaties, international conventions, and everything. All those secondary sources, they are of persuasive effect, and the court is not bound to follow them. You can only use them in court to buttress your point, or to stress further that probably is an international law that is recognized globally. So you can use it as a persuasive force. Remember, Nigeria is not compelled to follow all these secondary Nigerian courts are not compelled to follow secondary sources of law. What they are compelled to follow is the primary source. That is what they are compelled to follow. So secondary sources of law can only act as persuasion. However, it may be relied upon if, for instance, in that instant case, we can't find any particular primary source that talks about that instant case. There are some cases that are par incurium. When we say par incurium, that is, they are new cases. They have not been brought out. They have not been brought to the court at all. So those kind of cases, if for instance now a case involving AI, we know that as of recent there have been no strong statute that has been made regarding the operation and the regulation of artificial intelligence in Nigeria as of now. So if, for instance, a case is coming up under this artificial intelligence, we are going to rely on international laws that have been made already regarding artificial intelligence. We're going to rely on, probably where it has been stated in law textbook, not by just regular people, but people of high reputation, authors that are highly recognized for giving, solid ideas in the legal field. So this is exceptions where secondary sources can now be relied upon. These are exceptions where secondary sources can be relied upon. So with this, we have discussed the sources of law. We have explained all we need to know about the sources of law. And we identify the sources of law as the Constitution, which we say is the chronon. And it's the alpha and the omega, the fons et origo. And remember that section 1 sub 3 of the Constitution of Nigeria, it makes any other law that's contrary to it void to the extent of its inconsistency. So when we say a law is void to the extent of its inconsistency, it doesn't mean that that entire law will be discarded. For instance, now a statute was made, or maybe a bill was passed, and that bill contains some elements which are in contrary with the provisions of the chronon. So what will happen is that the parts that are contrary to the Constitution, they will be removed. They will be set aside. Whereas the ones that are in consonance with the law, they will be left. So that's what we mean by void to the extent of its inconsistency. It doesn't mean the whole law will be void. The extent of its inconsistency, to the extent in which that particular law is unconstitutional, those parts will be removed. So, but however, if the whole constitution is void, they could remove everything now. They remove the whole thing. So that is what the Constitution is all about. And the Constitution, it also says that no one shall, acquire power unconstitutionally. And when we're talking about legislation, we said the decree and edict, they also form part of the legislation. Whereas the military acquire power unconstitutionally, because once the military comes into power, the first thing they do is to suspend Section 1 of the Constitution. They suspend it because it is making the military government to feel inferior, and the military do not want to feel inferior. What they say will happen is what will happen. They don't follow civilian governments. They don't wait to hear from the people. So military government, is they impose themselves on the society, on that particular state. If, for instance, that state is in a situation whereby, it really is in a state of emergency and it needs urgent intervention. That is most cases where military intervene. And Nigeria has faced some military regime. So, but today is not for military rule. What our focus is on the source of law. So with this, we have an idea. If, for instance, now you're not a lawyer, you're not a law student here, maybe you just want to know about the law. At least today, you now know about the sources of law. You now know, okay, this is what make up our Nigerian law. This is how Nigerian law is made. These are also aspects. And remember, law is law everywhere. So in as much as my focus is on Nigerian law, this also constitutes part of laws in other nations, at least to some extent. So the only distance may be how our own law is applied and maybe some differences in our law, but law is law everywhere. So with this, we have an idea of what the sources of law in Nigeria is, and maybe we can make more research, read up more, make some, browse more and know extensively these sources of law. So I hope you enjoyed this episode, and like I said, we'll be delivering more of these educative episodes for the public, for the general public to listen and entertain themselves with and learn, because law is very important, especially in today's society where the technology is advancing, AI is growing, so laws will be needed to regulate it. So a lot of cases are going to come up as regarding these new advancements in the world. So we need to be abreast of the law so that we don't fall victim, because like they say, ignorance of the law is not an excuse. So you need to be aware of the law. So with this, we have come to the end of today's episode. We hope it was as interactive as possible. So please do wait to like, share, and comment, and also recommend this podcast to your friends, families, or anyone who is interested in learning about the legal system. So my name is David Njoku, and I'm the host of this podcast. I'm also the CEO and founder of the podcast. So I'm a law student, like I always say, and my aim here is just to share ideas. I'm also here to learn. So everyone can share their ideas. You share your opinions. You can share in the comment section. From there, I will learn. It's an interactive platform for all of us to learn. So it is open for everyone to suggest their ideas on what they think. Any idea you have on the legal concept or the legal system or the Nigerian legal system. So feel free to share your ideas. So once again, I thank you all for taking your time to listen. If you've listened to this extent, I really appreciate. It's not easy to stay and listen to this episode down to this level. So I really appreciate the efforts. So thank you and thank you. Have a nice day.